Is this the beginning of the end for Tesla? And more importantly, does this settle who's responsible for when a self-driving car gets into an accident? In a shocking development, the guy who routinely promises totally unrealistic results might finally be held accountable. Yes, Elon Musk, the same man who has blown up countless rocket ships and the entire federal government in 6 months, has been called out in a Florida lawsuit. His company, Tesla, was hit with $200 million in punitive damages by a Florida jury, mostly because of Elon's false promises about the capabilities of Tesla's supposedly self-driving vehicles. And while these verdicts won't be precedential in the strict legal sense, it could be a sign of things to come as more and more plaintiffs start filing suit for these kinds of damages. Here in these lawsuits, the plaintiffs allege that Tesla and Elon have routinely claimed that Tesla's vehicles were safer and more autonomous than they actually are. And worse, the company has used public roadways to beta test unproven technology. And the jury agreed and slapped the company with $200 million in punitive damages. But that may be the least of Tesla's problems, because another lawsuit was just filed in Texas accusing Musk and Tesla of falsely propping up Tesla's stock value by lying to investors and the public about its technology. Now, these two lawsuits both hinge on one crucial idea, that Elon and Tesla have overpromised and underperformed regarding the company's autonomous vehicles. They've claimed that Autopilot is safer than a human driver, even though some studies have shown that not to be the case for Tesla, and they've beta tested those devices on American roadways. Plaintiffs in both cases are arguing that this marketing is deceptive and gives rise to legal liability. Now, relevant here, on April 25, 2019, 22-year-old Nibel Benavides Leon was standing beside a parked Chevy Tahoe with her boyfriend, Dylan Angulo. This part of Kelargo, Florida is close to the beach, and vehicles are often parked along the roadside near the intersection of Carl Sound Road and County Road 905. Now, it was dark, but the intersection was marked by a stop sign, a flashing red light, and several reflectors. George McGee had purchased his Tesla Model S earlier that year to use on his regular commute from Kelargo. At 9:25 p.m. on April 25th, he was driving the vehicle with Tesla's Autopilot feature turned on. Now, because Autopilot was abiding by the speed limit, which wasn't fast enough for McGee's taste, he pressed down on the accelerator to make the vehicle speed up. Now, despite McGee's decision to override the system's speed control, Autopilot remained engaged. And while cruising down Carl Sound Road, McGee dropped his cell phone. He was apparently rummaging around the floor trying to find the phone as the Tesla approached the intersection with County Road 905. McGee, who was not looking at the road, didn't brake. The car, which was supposed to have automatic safety brakes, also failed to brake or even slow down, despite registering the stop sign, reflectors, stationary vehicle, and pedestrians in front of it. The Tesla blew through the intersection with County Road 905 and struck the parked Tahoe while going about 60 miles an hour. The Tahoe then rammed into Nibel and Dylan, hurtling both of them into the bushes. She died and he was left with permanent injuries. The Nibel's family filed suit in Florida State Court. Tesla removed the case to the federal court in the Southern District of Florida, where Judge Beth Bloom presided over the case. Angulo's separate lawsuit was then consolidated with this one. Now, in their amended complaint, plaintiffs argued that Tesla was liable under 4 counts: defective design, failure to warn, defective manufacture, and negligent misrepresentation. The first 3 counts are strict liability claims, which means that Tesla can be held responsible for damages or injuries regardless of whether they were negligent or intended to cause harm. And to support their claims, plaintiffs presented a long list of supposed misrepresentations, safety problems, and negligent acts, starting with the name Autopilot itself, which plaintiffs claim was misleading on its face. They cited Tesla's own survey, which found that 47 out of 675 drivers thought the term meant the car could drive itself. And the plaintiffs' filings pointed to a string of other misleadingly optimistic claims from Tesla and CEO Elon Musk, including the company's famously misleading 2016 Paint It Black video. The ad made Autopilot look flawless, but Tesla employees later told the New York Times that the video was heavily edited to hide the vehicle's mistakes, including a crash into a roadside barrier. And instead of warning people about the system's limits, Tesla has allegedly fueled overconfidence. In the opening of the Paint It Black video, the company declares, quote, "The person in the driver's seat is only there for legal reasons. He's not doing anything, the car is driving itself." And according to plaintiffs, statements like this convinced drivers, including George McGee, that they could take their eyes off the road and trust the car to avoid accidents. Now, Musk and Tesla have also repeatedly said that Autopilot is safer than human drivers, though this claim is contradicted by actual scientific studies. A recent study by the nonprofit Insurance Institute for Highway Safety found that partial automation features like the ones in Tesla's vehicles don't actually prevent crashes. Though Musk has publicly claimed that, quote, approximately 500,000 people would have been saved if Tesla's Autopilot was universally available. And Musk specifically called out the accuracy of the vehicle's braking system, claiming that, quote, particularly anything large or metallic or anything that's dense, the radar system in the car, we're confident will be able to detect that and initiate a braking event. The plaintiffs argued these kinds of statements would have led McGee and others to over-rely on the vehicle's ability to prevent crashes and brake automatically. And the plaintiffs also argued that Tesla had put everyone else in and around Tesla vehicles at risk because Tesla uses its drivers to train the Tesla Autopilot system. For Tesla, this is a feature, not a bug. Musk himself has proclaimed that this is part of why Tesla has had such great autonomous vehicles, because Tesla's been able to collect all data from drivers who are using unproven technology on public roadways. In a 2023 earnings call, Musk said, quote, "This is a data advantage that really no one else has. Those who understand AI will understand the importance of data, of training data, and how fundamental that is to achieving an incredible outcome." So his plan was to crowdsource a plan. And while Tesla could claim that the drivers of its vehicles consent to the risks of using unproven technology, there's no way the company could claim that every other driver, passenger, or pedestrian legally consented to those risks. So plaintiffs contended that Tesla also had ample evidence that its cars were unsafe. The complaint listed dozens of crashes involving Tesla's Autopilot feature, which they argued ought to have put Tesla on notice that its vehicles are dangerous to drivers, passengers, and third parties. But not to be outdone, federal agencies and consumer safety advocates had also repeatedly warned Tesla that its promises about Autopilot might be deceptive and its vehicles were unsafe. Several members of Congress openly urged the Federal Trade Commission to investigate Tesla's deceptive promises regarding Autopilot, and the National Highway Traffic Safety Administration had already investigated Tesla several times and even forced the company to conduct a recall of its Autopilot technology. After a 3-year investigation, the agency declared that, quote, "Tesla's weak driver engagement system was not appropriate for Autopilot's permissive operating capabilities, and that resulted in a critical safety gap." Plaintiffs also argued that Tesla had plenty of evidence that drivers were misusing the Autopilot feature, but the company had chosen not to do anything to prevent that misuse. While other auto companies had developed safety features to mitigate the risk of driver distraction, over-reliance on autonomous features and delayed driver reaction, Tesla allegedly had not. And plaintiffs offered several examples of potential safety fixes Tesla could have deployed. For instance, more obvious warnings when drivers take their eyes off the road or hands off the wheel, or a failsafe that would prevent frequently inattentive drivers from continuing to use Autopilot. But instead, in this instance, McGee was able to continue to use Autopilot even after the system had flagged him with numerous warnings for distracted driving. According to the vehicle's data log, quote, "During McGee's 3-month ownership of his Tesla, he experienced 23 strikeouts due to distracted driving. When McGee received a strikeout, he frequently pulled over, placed the vehicle in park, and back into drive. Then he continued the trip with Autopilot back in use. On the final drive cycle on which the collision occurred, McGee had already received 1 strikeout and a total of 5 audible warnings. He was 1 chime away from another strikeout prior to impact." Judge Bloom in this case noted that, quote, "Although Tesla recorded McGee's abuse and misuse of the Autopilot system, Tesla did not change his behavior, provide additional training, or significantly restrict his use of this feature." Plaintiffs also argued that McGee never should have been able to use Autopilot on a small local street like Card Sound Road at all. The Autopilot technology was only designed to be used on highways, so Tesla should have geo-fenced that technology, only allowing it to be used in the kinds of situations it was designed for. And they also argued Tesla should not have allowed Autopilot to remain on while McGee was overriding the speed limit. Now, after a long series of back and forth motions and several suspicious discovery evasions by Tesla filed a motion to dismiss, and Judge Bloom evaluated which of plaintiffs' 4 claims, defective design, failure to warn, defective manufacture, and negligent misrepresentation, should be presented to the jury. Now, under Florida law, a defective design claim requires plaintiff to prove that a product produced by a manufacturer was defective or created in unreasonably dangerous condition that proximately caused an injury in the plaintiff. And the plaintiff has to show the product was defectively designed under the consumer expectation test, the risk utility test, or both. Now, under the consumer expectation test, a product is defective if, quote, "the product fails to perform as safely as an ordinary consumer would expect when used as intended or in a manner reasonably foreseeable by the manufacturer." And under the risk utility test, a product is defective if, quote, "foreseeable risks of harm posed by the product could have been reduced or avoided by the adoption of a reasonable alternative design, and the omission of the design renders the product not reasonably safe." Now, regardless of which test is applied, manufacturers aren't required to create the safest design possible. They just need to design a product that isn't unreasonably dangerous. And in order to satisfy the 4th factor, proximate cause, a plaintiff must show that but for the defect, the injury would not have occurred, and that the conduct of the defendant was a substantial factor in creating the injury. Now, Tesla argued that McGee had clearly admitted that he knew that Autopilot didn't make the car self-driving, and that he needed to continue to pay attention and actually operate the vehicle. So even if Autopilot operated in accordance with the plaintiff's aspirational standards, it wouldn't have prevented the crash. Tesla argued that, quote, "this accident was solely caused by McGee's own conscious and deliberate decision to pick up his phone while manually operating his vehicle." But Judge Bloom rejected Tesla's claim that the crash was entirely McGee's fault and that the company bore no responsibility. Judge Bloom found that plaintiffs had demonstrated that Autopilot's design led McGee and other Tesla drivers to over-rely on Autopilot. She also held that plaintiffs provided sufficient evidence that allowing Tesla drivers to use Autopilot outside of its original design parameters on small roads, for instance, was unreasonably dangerous. If Tesla had fixed or reduced these foreseeable dangers, Judge Bloom reasoned that McGee probably would have been paying more attention and would have been better prepared to avoid the subject collision. The judge concluded that while McGee shared some blame, Tesla's flawed design was a substantial factor in the accident. As a result, she refused to dismiss the claim and ruled that a jury should decide it, along with a related failure to warn claim. But if we skip ahead to the results of the trial, spoiler, Tesla lost, we can learn a lot about the cultural error by examining the headlines across political divides. Now, news of the $240 million damages award was covered by over 450 sources, making this a major story, with 32% coming from the left, 53% coming from the center, and only 14% coming from the right. And on the left, headlines use the word fatal, complicit, and autopilot, which implicitly agrees with the plaintiff's 4 claims that we discussed: defective design, failure to warn, defective manufacture, and negligent misrepresentation. However, on the right, headlines were more likely to leave out the words deadly and fatal, and even go so far as to refer to the ruling as a $240 million fine, suggesting it was an unfair or unimportant ruling against Tesla. And while sources on the center used a mix of both of these rhetorical strategies, headlines were most likely to frame Tesla as partially responsible, implying nuance and complexity of the court's findings. Now, the headlines that you read first have immense power to shape how you understand the news, and that's why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. And right now, they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get the discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum, like this recent story of Elon Musk winning a big court case in California related to Twitter users posting politically charged AI deepfakes on Twitter. Nobody on the left covered it, with 85% of the coverage coming from the right and only 15% coming from the center. Now, it's my job to stay on top of all the legal news from as many sources as possible, but whenever I look at the blind spot feed, I usually find something that I missed. But that's why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the bias insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent and balanced. So click on the link below or scan the code today, or I'll see you in court. Under Florida law, a product can be defective due to a defective warning. To succeed on a failure to warn claim, plaintiff has to demonstrate 1, that the product warning was inadequate, that the inadequacy proximately caused her injury, and 3, that she in fact suffered an injury from using the product. To be legally sufficient, the warning label must, quote, make apparent the potential harmful consequences and must be of such intensity as to cause a reasonable man to exercise for his own safety caution commensurate with the potential danger. Now, courts evaluate this based on a reasonable person standard, rather than on each particular plaintiff's subjective appreciation of the danger. And even if the warnings are inadequate, plaintiffs must also demonstrate that the defendant had a duty to provide a warning. A company doesn't need to provide a warning if the danger is obvious or if the average user would be aware of the risk. So here, plaintiffs argue that the existing warnings were inadequate because Tesla's misstatements would have misled McGee and the average consumer about the real dangers of autopilot. They pointed to McGee's own confusion. While McGee knew he was ultimately responsible for driving, he stated that he bought the top-tier package, believing it would, quote, keep him in the lane, avoid crashes, and direct him where he needed to go. Plaintiffs claim that this evidence showed that Tesla's warnings were unclear, hard to access, and incomplete. For example, Tesla never gave drivers clear notice that Autopilot was still in beta. The owner's manual warnings were also buried and hard to find because the manual was only online, making it difficult for consumers to access. And the car's warnings weren't strong enough to actually alert inattentive drivers. Plaintiffs argued that these failures played a role in the crash.
Okay, here's a great place to maybe go on my phone some more and get kicked off. Alright, I'm not paying attention. There's all this stuff going on around me. Oh, there you go. Auto steer unavailable for the rest of this drive.
Even if McGee chose not to read the owner's manual, the manual's inaccessibility was itself a flaw. And even if the manual's content was adequate, the fact that it was hard to access made the warning defective. Tesla countered that it only has to warn customers about dangers they don't already know, and that aren't obvious to a reasonable person. Driving without paying attention, Tesla argued, is obviously dangerous, even with autopilot. And since McGee knew that, the company said it had no duty to warn him. And even if it did owe him a warning, Tesla insisted its existing warnings were sufficient. The first time McGee used auto steer, he had to acknowledge the system's limits, including keeping his hands on the wheel, watching the road closely, and being ready to take control at any moment. Tesla said these instructions were enough to ensure safe use of the car. And finally, Tesla argued that even if its warnings were lacking, the plaintiffs hadn't shown that those shortcomings actually caused the crash or their injuries. In his deposition, McGee admitted he did not read the existing warning, and Tesla argued that even if he did, there's no evidence that it would have changed his behavior or prevented the accident. Judge Bloom sided with the plaintiffs, finding that Tesla had a duty to provide more explicit warnings about the dangers of autopilot because those dangers might not be obvious to the average user. She agreed that the term autopilot itself might make users think that the car was self-driving when it actually was not, and that Tesla's leadership had, quote, encouraged drivers to treat their cars as if they were actual self-driving vehicles. And Judge Bloom waved away Tesla's defense that even if the average driver might have thought autopilot meant self-driving, McGee didn't actually believe that. As Judge Bloom pointed out, McGee had testified that he thought autopilot was, quote, co-pilot and, quote, understood it would keep him in the lane, avoid crashes, and direct him where he needed to go. Judge Bloom considered the text of Tesla's on-screen warnings and found that they didn't actually inform users about the potential risks of relying on autopilot. Instead, she found that the company's warnings looked more like instructions. And the company's owner's manual did contain adequate warnings, but Judge Bloom found that they still may not be legally sufficient because the manual was only available online. And she left this question for the jury to decide. Though on the other hand, Judge Bloom dismissed the manufacturing defect claim because there was no evidence that McGee's particular Tesla deviated from Tesla's original intended design. And she also dismissed the negligent misrepresentation claim because there was no evidence that Tesla made misrepresentations to the plaintiffs themselves. So then the judge turned to the question of punitive damages. Now, punitive damages are meant to function differently than compensatory damages. Compensatory damages are meant to help compensate the plaintiff, for instance, for paying medical costs or lost wages or pain, the actual damages that they suffered. Punitive damages are meant to punish the defendant for its wrongful conduct and deter similar misconduct by it and other actors in the future. Now, Florida's statute on punitive damages, section 768.72, specifies that, quote, a defendant may be held liable for punitive damages only if the trier of fact, based on clear and convincing evidence, finds that the defendant was personally guilty of intentional misconduct or gross negligence. And under that statute, intentional misconduct requires that, quote, the defendant had actual knowledge of the wrongfulness of the conduct and a high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct, resulting in injury or damage. And to establish gross negligence, the plaintiff must show, quote, the defendant's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. Additionally, the Florida Supreme Court has held that in automobile products liabilities cases, the standard is whether the car manufacturer exhibited a reckless disregard for human life equivalent to manslaughter by designing and marketing the vehicle. So plaintiffs argued that they had ample evidence to demonstrate that Tesla had actual knowledge that autopilot was dangerous. They pointed out that the National Transportation Safety Board had warned Tesla that it should prevent autopilot use on smaller roadways, and they argued that prior deadly accidents involving autopilot should also have put the company on notice that drivers were misusing autopilot. Now, plaintiffs argue that instead of remedying those problems, Tesla allowed dangerous vehicles to continue to operate on public roadways so that it could collect more data to improve its product and ultimately increase profits. And Judge Bloom agreed with the plaintiffs that there was enough evidence to present the punitive damages option to a jury. She zeroed in on the geofencing issue, arguing that Tesla was on notice that autopilot was only designed to be used on specific kinds of roadways, and that its use outside of those parameters was dangerous. Therefore, Tesla should have prevented the use of autopilot outside of those situations it was designed for. And because the company failed to do this, Judge Bloom held that, quote, a reasonable jury could find that Tesla acted in reckless disregard of human life for the sake of developing their product and maximizing profit. So after the motions practice in July of 2025, the case proceeded to trial, and Judge Bloom included the following jury instruction, quote, you may consider harms that Tesla's conduct caused to persons other than plaintiffs in deciding the reprehensibility or wrongfulness of Tesla's conduct only if the harm suffered by those other persons were caused by the same or similar conduct of Tesla that harmed plaintiffs. And the jury did consider it and found that Tesla deserved $200 million of punishment for its misdeeds. And after the 3-week trial, a Florida jury awarded $129 million in compensatory damages meant to cover the plaintiff's medical costs, pain, and suffering, and $200 million in punitive damages to punish Tesla. Now, I'll mention parenthetically that the Supreme Court has put an effective cap on punitive damages. So generally speaking, you can't have the punitive damages be many multiples of the compensatory damages. And here, the punitive damages being less than 2x of the compensatory damages makes them much more likely to be held up on appeal. But this lawsuit was groundbreaking because it's the first time that Tesla has actually had to face a jury trial in a wrongful death suit. Now, there have been plenty of other deaths, but the cases have always been dismissed or settled out. And the jury found that while McGee was significantly responsible for the crash, the defects in Tesla's autopilot feature and the company's misrepresentations about that feature helped cause the crash. And the jury apportioned 33% of the blame to Tesla and the rest to McGee. So Tesla will only have to pay $43 million in compensatory damages. But because punitive damages are meant to punish, the company will be responsible for the entirety of the $200 million in punitive damages. Though Tesla argued that McGee was solely responsible for the crash and the company vowed to appeal. And in its public statement about the lawsuit, Tesla doubled down on the claim that Autopilot is a life-saving technology. The company said, quote, "Today's verdict is wrong and only works to set back automotive safety and jeopardize Tesla's and the entire industry's efforts to develop and implement life-saving technology. We plan to appeal given the substantial errors of law and irregularities at trial." But if you've been in a car or trucking crash with a Tesla, you'll want a good lawyer. Luckily, I know a guy. Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, "Can you help me find a lawyer? How do I know if this attorney is any good?" And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.